Ain't nothing cut off. You stealing, like one girl said, if you stealing from somebody, you're not going to admit that you stealing from them once they find out. So let me get to the point. Stop playing with me. And you're not paying nothing for the record. You discharging your debt. You understand? You discharging it. It's the difference between discharge and payment. It's yet it sound the same. Okay? So it don't even matter what order you kind of do. So I'm just going to go to the top and I'm going to say, money order by accommodation. Okay? Y'all following me? And see that person right there? That's not you. That's not you. That's not me. You hear me? That's not me. This right here is for the entity, the fictitious entity that was created the moment I boarded the dock. Okay? This is not me. I was pronounced dead upon arrival. You understand? This right here was created in my place. Somebody got to be the liaison, okay? The middleman. Somebody got to be the middleman. So, boom. Look, and they put Mr. I ain't even see that shit. You look at that, Mr. Are you serious? That just goes to show how fictitious it is, y'all. Like, it just makes me so mad. Like, y'all don't understand, bro. Y'all don't understand, man. All right, boom. So let me keep going. Money order by accommodation. And I'm going to put, and I hope I don't cry. I hope I don't cry, because I will, real quick. Hold up. All right, my beneficiary, Okay, Mr. Grown, I see you, baby. I see you. I'm back, Fed. Okay, all right, Vietnam. All right, I see you. And this is how I'm going to write. Okay, that's my beneficiary name. Okay, that's how you write it out. You can write out like me. You can put a little different symbols in it. It don't even make no never mind. Just follow me now. Follow me. All right. And after you let them know who the beneficiary is, you come down and you gonna write out like a check. You gonna write out the payment like a check. See what I'm saying? I hope y'all can see. Y'all, I feel like I need my dictionary in front of me. Okay, and this is what we gonna do. First of all, my son crying, y'all. He dookie. All right, well, I'm going to go change him. Give me 1 second. Shit. Now I ain't gonna hold y'all long. On God, I ain't gonna hold y'all long. And I thank y'all for showing out for me. Because like I said, y'all ain't got to say nothing. Y'all ain't got to do nothing. Just try it for yourself and see how far you go. This is how I pay my bills, y'all. You know what I'm saying? Now, here go the part y'all waiting for. The laws, okay? These are the laws that I'm going to use on my coupon, okay? And I'm going to start down here at the bottom. Excuse me. Make sure y'all can see. 15.
What's up, everybody? So this is something I feel that everybody probably has troubles with because they don't know about it. And so when you go into court, you're dealing with everything's civil. There's no criminal. Everything's civil. Rule number 1 of the Federal Rules of Civil Procedure. All cases are civil. But the Federal Rules of Civil Procedure, Rule 52, applies in civil and criminal actions with equal force and effect because criminal is always civil in nature. No civil or criminal cause of action can arise lest there be a contract. See Eodes versus Marks, 249p, 2d, 257, 260. There is always a presumption that a contract exists and that the responding party is a corporation. Under Rule 52, which is the same in all states as in the federal rules, the Texas Court of Appeals, Fifth Circuit, has ruled of the finding of fact by the court that the failure of any adverse party to deny under oath the allegation that he is incorporated dispenses with the necessity of proof of the fact. Thus, a presumption becomes a finding of fact by the court unless rebutted before trial. So when you go into court, if you don't file an affidavit of non-corporate status, the presumption is that you're a corporation, which up until the last couple of years, I would have never even known. So when you guys go in there and you say, hey, that's me, and you claim the corporate status, your name in all capital letters, they're gonna assume that that's what you are. Even if you know about this and you don't go in there and say, hey, that's not me, they're just gonna assume that you are the corporation, and that's what it is. So in any case, an affidavit of non-corporate status and an affidavit of citizenship, or a judicial notice of non-corporate status and an affidavit of citizenship, is going to be what you need to file on any case, or else you're going to be treated as if you're a corporation, and that's why statutory law would apply to you. So, yeah. In the case Dr. Pepper versus Crow, plaintiff pled defendant was a corporation. Defendant did not deny by verified pleading pursuant to TRCP 52 and 83 that it was not a corporation, thus such fact was established. Louisiana Revised Statute, Art 2 or 429, corporation existence is presumed unless affidavit of denial is filed before trial. So you guys need to start filing this when you go to court.
I'm going to start with what law really is. Most of us think that we go into a courtroom and understand the difference between a court and a courtroom, that the people who purport to use law really use words of art to make you believe, in fact, that law is on the table when you walk into a courthouse or a courtroom, when in fact that's not true. And I would like to share with you tonight, regardless of your religious persuasion, what law really is. Law, and as Muslims would say, all law, is A-L-L space L-A-W. All law. All law. So for anyone who's of a Christian persuasion, don't be misled. And when you hear the term all law is God. All right? That is also what we would say in lawful terms a misnomer. Allah is not God. God has no capacity and no standing to all law. Because God means governmental ordinance departments. There is no comparison. Now, who can use law? Law can only be used by people who are in their sovereign capacity. And as I will share with you tonight, the majority of the people in the world, and I'm not going to get into all of the details about that, but the majority of the people in the world, 99% of them live in slavery today. So in 1863, via the Emancipation Proclamation, and I challenge you to go look in a law dictionary and look up the definition of emancipation and proclamation, and you will see that a proclamation is not a law. A proclamation is a public announcement by elected officials. It is not a law. So the Emancipation Proclamation of 1863 did not set any slaves free. What it did was standardize slavery, the United States being the model for the standardization of slavery, that all of the other nations around the world, as they reduced their people from their sovereign capacity and forced them to join nation states, then they were able to issue statute, codes, ordinances, resolutions on them. And a statute, as in a state statute of the Commonwealth of Pennsylvania, is not a law. It is corporate policy. of the corporation that calls itself the Commonwealth of Pennsylvania Incorporated. All right? Now, a code is not a law. The United States codes, the code of the laws of the United States of America that are used in federal court and the Supreme Court are not law. They are what they say they are. They are codes, ordinances, and resolutions of a municipality of the city of Philadelphia, which is a private nonprofit corporation that calls itself the City of Philadelphia. An ordinance and a resolution, as in parking ordinances, they are not law. They are what they say they are. They are ordinances and they are resolutions. All right? And the reason they are not law is because the only people who can issue law are people who are acting in their sovereign capacity. And the people who sit in these seats as elected officials are not, in fact, in their sovereign capacity. They are in a corporate ward status, meaning that they are wards of the state. They are members of the corporation, which is a nonprofit, that calls itself the Commonwealth of Pennsylvania. And as long as they have a birth certificate on record with the Commonwealth of Pennsylvania, with that birth certificate being a contract, a birth certificate is a contract. And as long as you have a contract with the Commonwealth of Pennsylvania Incorporated, you belong to them, and that's what slavery really is. All right? So who can use law? If you are a member of a corporate ward state, if you are a member of a corporate ward nation that calls itself the United States of America, you are a citizen. Look in the law dictionary and look up the definition of citizen. A citizen is not a sovereign. A resident is not a sovereign. Therefore, if you use an address, which is a fictitious number associated with a designation issued by a corporate ward, right? Then you become under the jurisdiction of those people who are also corporate wards, but who are also slaveholders. All right? So if you are operating in that capacity, law does not apply to you. If you are a resident of the city of Philadelphia, which is a private nonprofit corporation, and you say you are a resident of the city of Philadelphia, then the ordinances and the resolutions of that private nonprofit corporation apply to you. If you are a citizen of the Commonwealth of Pennsylvania Incorporated, which is a private nonprofit corporation, then the statutes of that nonprofit corporation apply to you. If you are a citizen of the United States of America, which is a private nonprofit corporation, then the code of the laws, right, apply to you. But if you are a sovereign of the Moorish Empire, those ordinances, those resolutions, those codes, those statutes do not apply to you because you are not a member of the corporate ward state. It's as simple as that. And they understand the difference. This is why on their documents, they use words of art. They use the word label. They use the word person. They use the word address. All of these things that place you in their jurisdiction, and you unknowingly fill out forms every day. And every time you fill out a form, you enter into a contract. I don't care what kind of form it is. It's a contract. A driver's license application is a contract. A Social Security application is a contract. When you call up the telephone company and you make a verbal contract over the telephone, this is why they can bill you. When you sign a deed, it is a contract. When you fill out a voter registration form, it is a contract. Does everybody understand that? Don't ever think anything that you put your signature on becomes a contract. All right? Now, the fact that you are not in your sovereign status means that you make a contract as a minor. They don't care. They know you are a minor because, and to be other than a minor,
on a brass plaque somewhere in an obscure location inside the hospital, probably under a stairwell, it says this hospital is a foundling hospital. Foundling hospital. So a mother, 9 months pregnant, walks into a foundling hospital. She goes through a major medical procedure called childbirth, where she's in pain and under duress. She's probably under the influence of painkillers of some type. You got to be pretty tough to give birth. I wouldn't want to do it. Anyway, she has that beautiful baby, and all she's thinking about is getting home with it and leave it. But see, the baby in history, throughout history, came out of the water, was tugged through the birth canal, was docked at the dock by the dock tender, where a bill of lading was filled out and received on the cargo, where its soul was taken, its soul plates, the footprints of the baby. The placenta was taken. Okay? They took the baby's soul, and they sent it out with a tug, and is presumed dead and lost at sea until it should return and claim its minor estate. No physician delivers a baby. Only a doctor does. Doctor is dock tender. The baby is a vessel, a ship. That's where the all caps name comes in. If you look at the names of ships, they're in all capital letters. Okay? No one disclosed the terms and conditions of the contract, yet you were handed a stack of papers to fill out, and you were only told, and this was right out of the nurse's manual, this is just to register your baby with the state and to give it a name. And you fill out the paperwork, and you name your baby, and you sign as an informant. What is the legal definition of the word informant? Someone who gives someone else up to another, thereby giving the title and equity of your child to the state. This creates a doctrine called parens patriae. Guess I should write that. It's Latin for state is your parent. State is the parent. Creates the doctrine of parens patriae. Through this doctrine, that's how they have control over you. And through your consent of being a citizen, a person, a resident. 3 things you never want to be.
That's not hypothetical or conjectural. It's concrete and evident. I can prove it that's what it is. In fact, if you go to the PIMCO bond website, it tells you right on the, you know who PIMCO bonds are?
Hmm.
I doubt if anybody even knows who PIMCO is.
I've been to their website.
Okay, that's the U.S. arm of Allianz SE out of Munich, Germany. It says right on their website that they forward your mortgage payments as cash flow claims to investors. So you're not making payments on a mortgage, you're making payments on an investment contract. And if you read your deed of trust, it has a 30-year maturity. It says that on the note. If you go to 15 USC 78 CA 10, it says all notes are securities, except those with a maturity of 9 months or less. That's the exclusion rule. So the only securities that are notes with a maturity of 9 months or less. All notes have a maturity of 30 years or more. I've seen them as low as 12 months. Then it goes to 15 years, 20 years, 30 years. But they're all securities. They're not notes. And all securities are governed by Article 8, not Article 3. And it says that in 4-102 under applicability. It says that if it's an item that's includable in Article 3 and it's governed by 8, 8 controls 3 and 4. If there's a conflict, 8 controls 3 and 4. Article 4 deals with transfers and deposits in banks. Article 3 deals with negotiable instruments, but you're not dealing with a negotiable instrument. A security is a non-negotiable instrument. It's a financial asset. Go read 8-102, subsection 5. Financial assets, not a negotiable instrument. So you're giving them a security and they sell it to investors. Then they forward your cash flow claims to the investors.
Have you done this yourself?
Well, yeah, I went into court, argued this in a courtroom, and we were doing a telephonic, this is on a mortgage foreclosure case. I was in the courtroom live talking to the judge face to face about this. I was saying this very thing that I'm saying now to the court. And the attorney was on the phone. This is a woman.
Benjamin Franklin said nothing is certain except death and taxes. This is what he meant. Go to the IRS website and pull up publication 6209. I'm going to show you how you're dead in the eyes of taxes. And go to section 4, which is document locator number. And what you're looking for is code 5. Code 5 is information return processing estate and gift tax. Then you're going to go back to this section and you're going to click on section 2, which is tax returns and forms. Now, when you get a job, your employer wants you to fill out a what? A W-4. That is called an employee withholding certificate. Look at that tax class, 5. Look at your W-2, your wage and tax statements, class 5. Social Security benefit statement, class 5. All your 1099s, A through S, class 5. Class 5 is information return processing for estate and gift taxes. Go to the Internal Revenue Manual, look up section 21.7.13.3.2.2 subsection 2. And it says, an infant is the decedent of an estate or grantor, owner, or trustor of trust, guardianship, receivership, custodianship that has yet to receive their social security number. So when you fill out this W-4 form, you're filling out this withholding certificate for your estate. When you get this W-2 form back so you can file your 1040s, this W-2 statement is for the wages and taxes for your estate. For those who don't know what a decedent is a legal term used to refer to a deceased person, meaning you are dead. And again, if we look right back at the Internal Revenue Manual, it says an infant is the decedent of an estate. And again, these are estate tax forms. If I'm not mistaken, on the 1040, you get a $12,500 exclusion on your income. But if you filed estate tax returns, there's $3 million and some change for exclusion on the estate side, and $1 million and some change for exclusion on the gift side. Read, people, read. And if people were wondering about the master file that the IRS supposedly has, it's called the debtor master file. It does exist, and here are the master file codes that you can go through so you can find out what specific information that you want to request.
If you got something on your credit report and you really want to get it removed by disputing it, you might really want to listen to this. So here's a mistake that I see a lot of people make when using consumer law. Pay attention to this. When disputing certain accounts, you have to know what law verbiage to use for each person, because you can use the wrong law verbiage and get marked as a frivolous account. This is how you address debt collectors, banks, and credit reporting agencies. Regardless of what section you're at, your claim and your argument is that you're always the consumer. You're not the creditor. You're not original creditor. And banks, dealerships, and credit reporting agencies are not debt collectors. All banks and dealerships fall under the Truth in Lending and the FCRA. Therefore, you should never use the FDCPA to identify banks and dealerships at all. The FDCPA is mainly for third-party corporations such as debt collectors. For example, if you're addressing the CRA, a credit reporting agency, you want to be using the FCRA. This would be people like Experian, TransUnion, Equifax. You want to define yourself as a consumer under 15 U.S.C. 1681 AC. This go for banks and dealerships, as far as cars and stuff. If anytime you coming after them, you always want to address yourself as a consumer under 15 U.S.C. 1602 I. 3. This one is very important because this is where everybody make mistakes at. Debt collectors. If you're ever going after a debt collector, you always want to address them with the FDCPA laws and define yourself as a consumer under 15 U.S.C. 1692 A3. The term consumer means any natural person obligated or alleged obligated to pay the debt. And they give you a choice there. Which one are you? Obligated or alleged obligated? So as you can see, the credit reporting agencies, banks, and debt collectors, you're always defined as the consumer and not the original creditor. So you always want to make sure that you send the correct law verbiage to the right person, because you cannot send FDCPA laws to banks or dealerships. They will look at you like you crazy, and your remedy will be dishonor. And you also can be marked as a frivolous account, so be careful.
Literally sitting here about to record for my rescission class, and I'm like, I came across some information. I'm like, they do not get it. So, before I record, I'm about to drop some jewels. So, if you've been trying to rescind your car contract and get up out of that debt, that fraud, you need to stick around. So, I just decided to pull it up so we can jump right in and get to the main point. In a credit transaction in which a security interest is or will be retained or acquired in a consumer's principal dwelling, each consumer whose ownership interest is or will be subject to the security interest shall have the right to rescind the transaction, except for transactions described in paragraph F of this section. That was just to let us know we have the right to rescind. I'm not done. Now, if you come right here of this same paragraph, right where my finger is, the right of rescission applies only to the addition of the security interest and not the existing obligation. Listen, go read it twice if you need to. Listen to what that says and listen to what I'm about to explain to you. I had to pause the music. This is why it's important for you to have your original contract, because the retail installment contract that you have in place with the person, the company that you pay every month for your note, that is a retail installment contract that has a security interest on it. Your original contract does not have a security interest on it. In fact, if you have your original contract and went over it and seen the information disclosed, you would know that it's a sale and it's a complete transaction, and that your vehicle, the property, has already been paid for. It's sold, done, transaction sold, complete. Why do you think it's called a retail installment contract? Your original contract is not called a retail installment contract. It's called a used bill of sale. Most of them, but it's not a retail installment contract. This leads me to my point. 15 U.S. Code Section 1602 L for Larry states that a credit card, I'm gonna just read it. Just so y'all know I'm here, I had to pull it up. I don't play. 15 U.S. Code Section 1602 Definitions and Rules of Constructions. Remember I said L, you got M, N, R. We're focusing on L. The term credit card means any card, plate, coupon book, or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. Now, when you go to buy a car, an extension of credit, a house, whatever, period, they want your social security number. We're really focusing on cars right now, but you get the point. They want your social. Now, this is my key. Coupon book or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. It clearly states a social security card. It's paid for, which is my point. I'm not saying that you cannot rescind your contract if you have the retail installment contract, but I am saying you already won if you have the original.